adjournment as we deliberate over the business of the people of Jamaica. May our deliberations, our consultations go with your blessing. Amen.
Thank you very much. All right, so the meeting, as said earlier, is a hybrid meeting. We have online Senator Allen and MP Crystal Lee. We recognize you both. It's only two persons, right? Are online?
Yes, thanks, Chairman.
Okay. And I would encourage you to use the platform in terms of the raise hand feature if you want to make a contribution. And then, of course, we have other members of the committee who are here, enough certainly to have a quorum. We want to welcome them. And then on the side of the technocrats or support team, we have our regular in-persons representing the various offices and the PAHO country office, Mr. Stein and his team. I want to thank you, Miss Aldridge and her team and others. Miss Seeley, you need to put your name tag so I can recognize that. Chair is in the name, right? Miss Seeley Brown. Is it Brownie or Brown? Brown. Okay, Brown with an E. Okay, a different shade of brown. and we have the staff here, of course, from Parliament. All right, Mr. Edwards is on his way, and so, but we're going to begin. He's very important to this session. Right, I was going to come to the apologies for absence. So, Dr. Longmore, any other? So, MP Corinthia Morrison and Mr. Michael Tucker of the NC, the National Council on Drug Abuse. I want to, for the record, apologies from them. I, in terms of my welcome and opening remarks, just to, again, welcome all of you and to hope that you had a good time off to the extent that we had a break, and to members who have been at this for some time, just to say that we're hoping that this now represents the final stretch before the bill is ready to be placed on the tables of Parliament for debate. Today it's about looking at the summary sheet of the decisions made by the committee on all the clauses of the bill, and then filling in some agreed changes that we had discussed but allowed Mr. Edwards and his team to provide the appropriate wording, which would be subject, of course, to our agreement. So when Mr. Edwards gets here, we will go through that. However, we need to go to the matters arising, the minutes, confirmation of the minutes of meetings held on May 10th and 11th. And you have both before you. So we're going to begin, of course, with the 10th. And I'm going to ask that we look through, starting with page 1. So that's minutes of the meeting held Tuesday, May 10th. Page 1. Page 2. Page 3. Page 4. Five. 6. 7. 8. page 9. Page 10. Eleven. 12. 13.
Mr. Chairman, on page 13, although minor, the, may I?
Yes.
Sorry.
Please go ahead.
Sorry. On page 13, although minor in the paragraph which begins Senator Allen, about 4 lines from the bottom, it says Mrs. Dennis Wright. One moment. Sorry, I thought I saw an error. No. My apologies, sir. My apologies.
Okay. All right. No problem. So that's 13. 14. 'And finally, page 15. So that's 15 pages. 15 is just few lines. All right. So if there are no corrections, can someone move? So moved by Senator Gale, seconded by Senator Golden. Any matters arising, or would we consider matters arising from the 10th? Any issue that you may want to raise? I mean, they may have been addressed in the subsequent meeting on the 11th. None? No? All right, so if there is none, can we move then to confirmation of the meeting held on Wednesday, May 11th, starting with page 1. Page 2. Page 3. Page 4. Page 5. Page 6. Page 7. Page 8. Nine. Ten. 11. 12. 13. 14. Okay, can I ask for Motion to accept if there are no comments or corrections, sorry. So moved by anybody? Senator Golding Campbell, thank you, who joined us virtually at that meeting. Seconded by Minister Malahoo Fort, thank you. And then if there are any matters arising from the meeting of Wednesday, May 11th. Any matter? I think those two meetings, I must say, the meeting of the 10th and 11th took us a very far way, and I want to commend members for making the time to participate over those 2 days. The comments are quite extensive in terms of the deliberations and the views on all the issues, and what it shows, hopefully, when this data or information would have been reviewed perhaps in the future, is that the committee spent a lot of time looking at the recommendations and the reports and the submissions. So I'm quite pleased with the... Yeah, go ahead.
That embedded in your comments was the fact that because I wasn't here, you reached very far.
No, you know, I don't think so. In fact, the truth is, I reflected all your... I reflected all your views. No, but it was a good, I think, two-day session. It was a good decision, and I want to thank members. All right, so if there are no...
Chairman, if I may,
yes,
before
go ahead,
we move on, you asked about matters arising from the last set of minutes, the May 11th minutes. I do recall a discussion about a particular case, I think.
A copy of what? The minutes? Yeah, we could. We could. Okay, so Mrs. Wright would have, or should have, should have, and therefore will. You didn't, did you? You did? Okay. All right, so we'll make it available. So who has it? Who you sent it to?
Chairman, it was sent with the documents that were forwarded to Ms. Brandon.
All right, so we'll follow through on that. Okay? All right, so thank you for that. So the next item would be the matter for discussion and continuation of clause-by-clause analysis of the bill, examination of outstanding matters. So Mr. Edwards is the best person to lead on some of the items, but we do have, or you all should have, a summary sheet of the decisions made by the committee. And I think it would be important for us to just go through those decisions, which I can read word for word, and then where we have an issue that requires greater clarity or where there is some outstanding wording to be placed on the table, we'll await Mr. Edwards, and then if we have to go back, we go back and deal with those, all right, in the interest of time. So if you all have that summary sheet in front of you, if you don't, please state, and we will make it available. I would like to begin with Clause 1, short title and commencement, and the decision that was made there. Hold on, let me just get my copy here that I'm keeping. Right, so Clause 1, the decision that was taken was effective date, effective date for implementation to be adjusted to reflect the year 2022. No controversy there, I think, if you have a comment on that, but if we agree, you have a comment.
No, it wasn't the effective date to be implemented, what is the date of the bill that we had hoped to change. So Clause 1, this act may be set as Tobacco Control Act 2022, as opposed to 2020 as is here.
I was about to add in, Mr. Chairman, that the effective date of a law is something completely different from the year that the law is passed. The two are not the same thing. So the short title is to be changed from 2019 to 2022? Or 2020 to 2022? Yes. Or simply to be changed to 2022?
Okay. Ms. Brown, you had something to say? You were commenting aloud.
I'm sorry, Chair. No, I was just thinking in my mind that if it was tabled on that date, the same thing, Member Malahufut was saying that the date of operation will be a different date, so I'm not sure that we change it when we do our amendments, our list of amendments to take to the House of Representatives. If we ever change the date that the bill is tabled, so I was just seeking clarification from.
Chair, a question. How would the bill have been treated at prorogation? Would we have rolled the bill over? Would we have done that? We did? Well, if we did, when I think the 2020 stays.
Sorry, Chair, sorry. We're looking at clause 1.
Sorry,
Chair, if I may.
Who is
Marlene
that now?
Aldred.
Yes, oh, right, go ahead.
We're looking at clause 1.
Yes.
Clause 1 is not about tabling, so it should have the current year.
The current year.
Yes. And normally when...
So 2022.
Yes, and it could be 2023.
I just want to make sure that we're on the same page. So just say 2022 or 2020. I know we're in 2022 now, but okay. So is that agreed by all? Agreed by all? Yes, Ms. Brown.
I'm being told that it's an automatic amendment that's done by the...
So it's editorial?
Yes.
Okay,
Yeah,
fine.
I wouldn't call it an amendment, right?
Okay.
It's an editorial change.
All right, fair enough. So we move on. All right, so Clause 2, interpretation. The committee deferred the examination of Clause 2 until it completes the review of the other provisions, since changes to other clauses could impact that clause. So I think we agreed on that, so we'll return to that later on. Clause 3, objects of act. The committee considered the recommendation of corporate accountability, which reads, it is proposed to consider inserting in Clause 3E the following language. E, inform, educate, communicate, and in highlight, I suspect where the changes are, and raise awareness to the public and or any public body about the addictive and harmful health, environmental, economic, and social consequences of the use of the tobacco products and relevant products, and about tobacco industry interference with tobacco control policies. There was a general acceptance for the recommendation to be accepted in part. There was not consensus with the word interference in the second half of the recommendation. It was suggested that further research be done on the use of the term interference in keeping with the WHO FCTC. Yes.
Just to remind us, Chair, that the definition of public body has a specific meaning. It's very limiting in the bill to a ministry or department of government, including either statutory body or authority, a government authority, and an agency.
I've tried to get Ms. Brown to take her mask off.
No, sir,
and
I can speak clearer. I'll try.
She hasn't done it, and we're not hearing you. You have to
Okay, I was saying, Chair, that the definition of public body, as it is defined in the bill, is very limited, because it speaks to a ministry, basically government entities and departments. And I was asking if we stay intent in the objects clause to limit when we speak of public awareness to the public, and then we speak of a public body, that we are is it the intention to limit it just to government agencies and entities? by the insertion of the word public body in that objective.
You're
object
asking
clause.
a question, or you're
Asking-
clarifying?
No, I'm asking, Chair, because of what is proposed that we insert.
It is, thank you, Chair. I think the intent of the committee was that it meant generally to the population, but because public body, as Ms. Brownlee has just indicated, is defined in the bill, in the clause 2, it would only restrict it to that particular area. And I want to think that we need to find a new word to substitute for public body right there.
Okay. Any suggestion of what that new word would be or wording would be? Mr. Edwards, you probably need to catch your breath.
Afternoon, Chair,
Afternoon, sir.
members and colleagues.
Yeah,
My apologies.
We're on clause 3 on the summary sheet, objects of act, and there is a suggestion to replace public body to ensure a more all-encompassing impact, if you will, of this particular clause. I wondered whether or not you had any thoughts on it. You're following?
In that context, I believe members of the public or the public would be an appropriate adjustment, Chair.
So replace public body with members of the public, or?
Thanks. So it would read awareness to the public or any public body.
Sorry?
Raise awareness to the public. Well, that should cover public body.
So
if we say to the public, that will cover.
Once you say and or, it covers everyone.
Chair, I think
But
he's
public-
suggesting that you take off and or and leave it at public. Is that correct?
Well, I was, but then I'm going further to say that the word public should cover all.
So take out public body, just say to the public.
Yes. Yes.
Just say to the public,
We'll cover
take out public body.
Any category.
So awareness to the public about the addictive, etc., etc.
Yes.
Is that what you're saying?
That is what I'm
Is
suggesting,
that what
Chair.
members are interpreting? And members are clear on that? Okay. So can we agree on that then? Yes? Any issues? No? Okay. So we agree on that.
I was just going to ask, what is the specific intention in relation to public bodies?
It's no longer there, but what
Well,
was?
if it's gone, then because it's a little more discerning. But if you want to move ahead, Chairman.
No, not at all. I'm not in any rush. I'm just saying that I interpret just keeping public or the public as including public bodies, unless you were saying public bodies for emphasis, but the public captures everyone. Am I correct? I'm correct. So I don't know. I mean, is there anything else you want to add to that in relation to the members' comment, Mr. Edwards?
Yeah, I think because of the entity that was making the recommendation, I'm aware that corporate accountability has a particular focus on, the public bodies and their governance and accountability. So maybe that's why they would have wanted to specifically mention public body. But in the context, public is wide enough to cover all. So I think it would be tautologous to speak of public and public body in this context. And this is an objects clause.
So is there a reason why you want to limit where you want to raise the awareness then? Because when I read it completely, The object of this act is to ensure compliance with the convention by controlling the manufacturing, supply, advertisement, promotion, and use of tobacco products or relevant products, including exposure to tobacco, so as to inform, educate, and communicate to the public the harmful health, environmental, economic, and social consequences of the use of tobacco products and relevant products. And you'd be adding here, and raise awareness to the public.
Yes.
And raise awareness to the public and to any public body. So what is covered in the proposed addition that is not covered in E?
Minister, whilst Mr. Edwards is at it, are you suggesting that inform, educate, and communicate is in fact raising awareness? I'm asking.
You're asking, and I am asking what it is that you're seeking to do, because when you educate, you do raise awareness on the areas that
I'm in support of the point. I'm just trying to.
Right, and when you inform, the information has an effect, as does education and communication. But if it is a particular signaling, that is why I was asking, because if you're signaling something in relation to public bodies, leaving it at the public in general does not achieve the same goal. That's why I was seeking clarity from your ministry personnel on the matter.
So let me get it. Let me get it now. So what you're saying then is that including public and public bodies would do greater justice to covering the sort of, is that what you're saying, Madam Minister, member?
Chairman, I was just seeking, I'm not necessarily saying that.
Okay.
I was just seeking clarity in relation to what you're seeking to do on this object in respect of public bodies. Because I know the law speaks to certain things. If you are in certain places in government, what you should and shouldn't do, can and cannot do. So I'm just seeking the clarity, because if we don't know what we're seeking to achieve, then we may not know the words that must be required to get the outcome. So that clarity is critical, and it goes ahead.
If I may, Chair, informing, educating, and communicating can be seen as activities that are going from one to the other, one person to the other. Raising awareness, though, is speaking to a more responsive outcome, whereby the person is not just informed, but the person has a heightened sense of understanding and appreciation of what has been shared with them. So I believe that is why raising awareness has that additional element.
So then why not simply include inform, educate, communicate, and raise awareness on the harmful, on the harmful health, environmental, economic, and social consequences of the use of tobacco products and relevant products?
But it's just that the reference to a particular object of the activity is useful.
Yeah, I agree with that. I mean, I think we have to, in fact, I tell you, I'm appreciative of the members' intervention, because I'm now having a slight change of heart about not including public bodies. What I would have done was to say public and public bodies, because I do believe that in terms of how you inform, educate, and raise awareness, you may need to take a differentiated strategy around targeting particular entities, and particularly entities that may be involved in the management of the process, as opposed to the general public who may just be...
But do you need to legislate that,
exactly.
or can it
I don't
be?
think we need to legislate that. I think that will come in the public, the advertising, whatever you're doing. I think, though, that if I recall, Chairman, when this particular proposal was made, and it came from Senator Longmore, I think here public body was just used loosely and not necessarily in relation to the interpretation at clause 2. So I am of the view that the public body could be public entity but we could just leave it at public. I don't think that there's a need to go further. That's my view.
Chair, how I read it now as it is that, so you raise the awareness and the education and you inform. But is it that you want to place a specific emphasis on public bodies?
This is the point I was making. And listen,
in order to ensure that you capture public bodies.
To me, public bodies
we don't need to.
May have a greater kind of duty, if you will, given that they regulate, if you will, coordinate, manage the implementation of the law, and therefore themselves may require a particular type of education and information, and in some instances even persuasion, which all are qualitatively different in terms of what the end results, what you're trying to achieve. And then, of course, the public. The public is more concerned with the harmful effects of tobacco. Public bodies, particularly those that have particular responsibility around tobacco consumption, may or would have a greater level of burden to provide information, to provide context, to provide support, and that level of preparation may be quite different from the general public. So I see value in saying one and the other, not one or the other, but one and the other, because there's a difference between a public body, which is constituted of members of the public, and just the general public. There is a difference. So I would move or and just keep and. No? Sorry?
Before you move, so it's always helpful to clarify who is going to be required to take action when you provide for something. Always helpful, because laws have to be implemented and they have to be enforced, which means once you provide for something, it imposes a duty on somebody else to do that something. And if they fail to do it, you have consequences. So I was really seeking the clarity. Who are you? What is being imposed on the public body? To do what? What are they to do? And what is to be done to them? That's all I was seeking some clarity on.
Chairman, if I may take off from the point you left off, and I do agree with the Minister about that, because I think the intent is just the public. Your reference to public bodies, and in particular those persons who are employed in the ministry who will have sight of or oversight of this particular legislation, based on clause 5 and the measures that you would seek to implement as minister, would certainly be part of that process, that they'd be educated, their awareness raised, and so as part of the internal need or the internal process of having them being part of this monitoring of the legislation. So I don't think we need to legislate for them in 3E. I still think that we could leave it at public. I don't think there needs to be any special emphasis on public bodies.
All right. Tell you what, I don't intend for us to re-examine all the clauses in a manner that seems as if we never examined them exhaustively leading up to this point. So I am hoping that we're not going to spend another, number of hours to do that. So I'm hoping, I don't have a problem with what you're suggesting, member, even though I do think that there may be benefits to the emphasis around public body, but I'm prepared to go with it because it can still, to my mind, work. So can we move on from this then by concluding that we will use public and take out and or any public body? All right? So let's move on from here. Thank you very much.
The other point was interference, Chairman, that we needed
interference.
to get some
So,
clarification.
okay, so there was an issue around interference and whether we should get an interpretation along the WHO FCTC. Mr. Edwards, were you able to get any clarity on that, or is there a comment from?
Yes, sure. To the point that, to the extent that we would suggest not using the word interference, but make reference to the tactics of the tobacco industry. And I believe we had initiated that suggestion at the last meeting of the committee. So we would speak to tobacco industry tactics in relation to public health policy for tobacco control.
And so what is it? Maybe I missed it. What are you recommending? The wording, we need to be more
Well, remember,
specific.
this is continuing from this is all tied back to the informing, educating, etc. So it's really informing, educating, communicating, and raising awareness about tobacco industry tactics in relation to public health policy for tobacco control.
But is the term interference too strong, or should it remain?
Well, we got the impression from the committee that there was concern about the term interference.
I'm not concerned, but okay. But I'm a democratic chairman. What was the recommendation as a follow-on to the task at hand, which was to determine the WHO FCTC? The PAHO WHO team is here. Were you able to do any sort of review of that to determine if that terminology is acceptable?
Thank you, Chair. So either wording can be used. In fact, I don't see any harm with adopting strategies, because the use of strategies is even a little bit wider.
Okay.
Yes.
So it's the least offensive, but it means the same thing.
And it might be a little wider.
Okay. All right. So okay, fair enough. And I'm hearing from you guys. That's fine. So let's do that then, Mr. Edwards. So the wording then is to replace interference with the strategies. Okay? Is that okay by all members? Right? All right. So we move on from that. We go to clause 4. Clause 4, 1F. It was agreed that the words, and I'm quoting, or advertising from clause 4, 1F be deleted. Was there an agreement on that? Yes, I think we agreed on that, right? We agreed on that. Yes? Yes.
Sure.
And then clause 41F2, it was agreed that the provision to be amended to read, prevent or minimize injury or harm to the health of the users or second-hand exposure to tobacco products or relevant products. And I think we agreed on that. Okay?
Yes, consistent with the Jamaica.
It was further agreed that the term second-hand exposure, quote unquote, be defined in the clause. Is there a definition?
We haven't provided a definition yet, Chair.
Well, no. You mean you haven't?
We're not sure that it needs to be defined. That was the other issue, whether we lose anything by not defining.
What is the preset? What is the sort of benchmark around second-hand smoke? I mean, it's a term that is fairly simple and straightforward, but is there a need to place a definition? Mr. Stein, you have a comment on that?
I think we could simplify this by just saying exposure as opposed to second-hand smoke, because it's the same difference.
Exposure.
Exposure.
To secondhand smoke.
No, you could just actually, instead of, it's actually to smoke itself, when you, tobacco smoke, I should say.
Okay, so, but your proposal is slightly different from what was the contention here. Whether or not we should define secondhand, but you're saying we should replace secondhand with exposure to tobacco.
Correct.
Because the exposure to tobacco may be what requires a definition, I would think, because exposure could be what? A pack of tobacco in my sight of view, or consumption of it. And if it's consumption, is there a way to consume from a distance without, you're exposed but not technically inhaling, for example? I mean, I'm just trying to get clarity.
If I may?
Sure.
I think that to return to the original premise here, if there's a need for a definition for secondhand exposure, we're happy to provide that to the committee.
Yeah, I mean, I don't think it hurts, but I'm wondering if there's any misunderstanding or misinterpretation around secondhand exposure.
Chair.
Yes.
The actual phrase in the clause is second-hand exposure to tobacco products.
Right.
So it is not second-hand exposure to tobacco smoke, which is how I understand the term second-hand exposure to be defined as exposure to smoke.
It has to be, yeah.
So what are we trying to say here when we say exposure to tobacco products? Is products an error there? Or is it that we were seeking to say two different things?
This is the point I'm making. It has to be exposure to the consumption of tobacco products, to the smoking, right? To the smoke itself. Isn't that what it is, Mr. Edwards?
It's intended so. And in fact, when we did our comparison and looked, for example, at the legislation in Guyana, they have a whole part of the legislation relating to protection from exposure to secondhand smoke. But when you read it, it doesn't define secondhand smoke. It just speaks to the restrictions on smoking, where you should smoke. So it really, to answer the question specifically, it should refer to exposure to secondhand smoke.
All right, so can we do that then and agree? Yeah? Okay. All right, Clause 5, government to undertake comprehensive nationwide education and information campaign. No amendment was recommended, that's good. Clause 6, education and information campaign to be carried out in schools. It was agreed that a similar language as at point 4 of the second schedule would be used to capture the recommendation suggested by the Jamaica Psychiatric Association to include places of entertainment and sports for education and information campaign. So that was agreed. We're okay with that?
Yes, Chair. So the wording provisionally would be inserted after the word workplaces in Clause 6 to add, so it would read, schools and other institutions of learning, and at all workplaces, sport, athletic, and recreational facilities available for the use of the public and in all communities throughout Jamaica.
Okay. All right. Are we agreed on that? Yes? Okay. And then Clause 7, policy of the government in relation to tobacco control. Subclause 3 to be redrafted to ensure the maintenance of protection or support for any possibility of manipulation of documentation for promotional purposes. However, the committee is to revisit the provision. Mr. Edwards, you want to guide us on that?
Sure, I think the technical team was hoping for any other information from the committee or any other thoughts, because it was reserved, it was stood down for further deliberation. So we were waiting for some conclusive determination from the committee on this.
Does the committee have any further comment on this? Yes.
I am I just want a little clarification. I'm not sure I was here when we had this discussion on subclause 3. What was the major concern expressed by the committee members which caused for this particular adjustment to subclause 3?
Our understanding, Chair and Member Guy, is that the concern was that subsection 3 is creating some exception to the general restriction in relation to prohibition from disclosure, and the fact that it would not apply to material which would be of a promotional nature. There was some disquiet about that because I think there was a concern as to how specific, or what was the scope of promotional in this context, insofar as it was creating this exception. So that we understood was the concern of the committee, because subsection 3 is providing that subsection 2, which would have been the requirement for all records, etc., of deliberations between government and industry to be made available, would not apply where the document was a promotional document or otherwise prohibited from disclosure under any enactment.
Who had raised this clause? Who had raised this issue? Member Guy?
No.
I recall, Honorable
Member Guy, you're asking for clarity.
No, I asked for clarity because I have here in my bill, I was asking the question, like what so? I have it written here. What would be examples of this particular thing that we want excluded from the provisions of subsection 2?
Well,
Mr. Chair?
A document that would be promotional in nature may, for example, be a record or document which would be speaking to, for example, information about maybe a meeting, deliberations, seminar, something like that, which would be rather neutral. And the sense is, why should there be an obligation to make that information available to the public if it is already promotional in nature? It's not what would be added if we're now going to say that promotional information should be subject to a requirement that it be made available to the public. Because if it's promotional, there is an implication that it would be information that is fairly harmless.
Mr.
Yes, Senator.
Yes, Mr. Chairman, the fact that we're having such difficulty in even understanding, my notes reflect that we were uncertain as to what this was seeking to address. And as such, it needed to be reviewed by Mr. Edwards and his team to determine what we were trying to address here. And I'm still realizing that we are not sure what this clause was proposing to remedy.
So, Mr. Edwards, it seems to be that the ball is heading back to your side of the court.
Yes. Mr. Chair?
You what? Oh, boy. All right.
Remember, Chair, this is an information management provision. So we have to think of how practical it is. This provision at subsection 2 is requiring the minister to ensure that documents relating to interaction and communication between government and the tobacco industry are made available. Fine, because we're talking about transparency and accountability. But if we have information if we have records or documents which are promotional in nature, and of course, this bill, at the heart of it, is dealing with the concept of advertising and promotion as one of the issues of concern. Then, if we have information, if we have records or documents relating to promotional material, why would there then have to be an obligation to make that available to the public if the very nature of it is promotional? So what it is doing is exempting two categories. Information that should be prohibited from disclosure, that I think that should be fairly clear, prohibited by at law from disclosure. So that does not have to be, there should not be an obligation to make that available to the public because it would be contradicting some other statutory restriction. And then the second element would be information which would be of a promotional nature, which may be information promoting some activity in relation to tobacco control, because of course the industry and government are not going to be always separate. There may have to be interaction. There will have to be interaction, in fact, for regulatory and other purposes. So the question is, I think it's an administrative convenience to say that if something is of a promotional nature, meaning that it is putting information out.
Mr. Edwards, the point, though, is, in the interest of time and efficiency of deliberation, that if you have to take that amount of time to explain it, it may need to be simplified. So it may not be an issue of the purpose or objective that you're trying to achieve, because that may be quite acceptable. But what I see here is that there's a question around rephrasing it, if you will, to make the issue more understandable. Now, I'm prepared to allow some time for that, because you clearly wanted more information based on what you said earlier. I see Member Malawi Fort. Let me hear what she has to say, but I think I'd allow you sometimes, Edwards, to try and rephrase and come back on that so we can move on. But let me hear Member Malawi Fort.
Thank you, Chairman. Now that the clause is brought back into focus, I'm seeing another issue with it at subclause 1. So it is provided here that the public health policy of the government, which relates to tobacco control, shall provide for the development and implementation of a national strategy for tobacco control, protection of the public against the influence of and interference by commercial and other vested interest of the tobacco industry, and ensuring that there is a transparent and documented interactions between government and the tobacco industry. I find it a little oddly worded, because you are translating your policy now into law, and if the policy translated into law is making provision for the development and implementation of a national strategy for tobacco control, then that task is to be imposed on someone, because someone would have to take responsibility for that. So providing for it in the way that it is now provided for, it is not, to my mind, the best way to do so in the legislation. So who's going to develop and implement the strategy? On whom is the responsibility placed to protect the public against the influence of and interference by commercial and other vested interest of the tobacco industry? And who is tasked with ensuring that there is transparent and documented interaction between government and the tobacco industry? And in the event that these things are not done, who is to be held responsible where the public, a member of the public, is harmed?
So, member, I appreciate the interpretation offered, but aren't some of those questions captured in other clauses based on? In other words, don't we have to consider the bill, the legislation in its totality to determine who is responsible and who is going to supervise and who is going to... I don't think you can get that out of one clause. I mean, just my thought. But Mr. Edwards, wouldn't you say? And if yes, can I allow you some time to rephrase for simplicity and clarity that particular clause. Is that all right? But
The whole clause, Chair?
Yeah.
For example, where in this law, just to ask your team to just remind me.
Is it?
Parent ministry.
Yeah.
Yeah, so I think that would be.
Chairman,
almost.
it's not such an irrelevant question. I know we may not want to spend a lot of time having gone through. I'm conscious of that. But how we provide for what is provided for, considering that the bill also has an object clause. Government is notorious for its omission. Notorious. So that it is
in charge of these actions that would be required under the legislation.
Members, let me try and pull back a little bit, because I fear that we're going to get into another round of conversation that almost requires us to go over the clause by clause discussion around the legislation. I don't think we can consider any aspect of the bill without taking in consideration the totality of the bill, the ministry that is responsible for the bill, and the related legislation around law enforcement and so on. And I think we run a risk if we begin to require this kind of specificity, that the bill becomes a standalone in all its parts, which I would humbly suggest no legislation actually hardly functions like this. It's a function of how government functions. And so naming as to who is going to enforce. I mean, we know that the police has a role, as the primary role around enforcement issues when laws are broken. We have inspectors too, health inspectors, who will inspect locations around public spaces and smoking in public spaces. Unless there is a particular reason that requires a new authority around enforcement, just using that as one of the considerations, then I would humbly suggest that we focus on the particular clause in its very narrowly defined objectives. And then at the end of it, we can probably comment in a broader way around what may be missing and how a related legislation fills that void. I think we'll be more efficient in terms of the administration of what's
Chairman.
happening. Yes, go ahead.
I'm just thinking, and I am warming to the suggestion by Honourable Minister, and I'm suggesting just that possibly we could, because the Minister's responsibility, the ministry's responsibility, you are the minister, and in 5 you shall implement measures to do all of these. In 7, it could be stated to cover all the concerns here that the minister shall implement the public health policy of the government related to tobacco control. And then, as a subclause for that, to say, in implementing this policy, it shall provide for such and such. Because at the end of the day, I think what Minister Malahoforth is.
But isn't it okay? You want to put it in for emphasis, because to my mind it's there.
No,
Minister,
Chairman,
may I
I
just ask for
understand where
clarity?
she's coming from, Chairman.
Sorry?
I appreciate your concern.
Is there any
Sorry,
part of the legislation
Minister,
that speaks
Member Guy, Minister.
Yes.
All right, just to help us, and I understand. And I'm also seeing another issue with subclause 2. And again, I understand that we have gone through a lengthy process and appreciate your concerns about the extent of the deliberations. So let me go to the easier point.
Just for clarity, I'm not trying to rush the conversation or discussion, because I need it to be thorough.
Right.
And
so
so on.
Please.
But what I'm saying is we did go through all the clauses and considered the bill in its totality. What we are doing now, seeking to do, I fear, and I could be misinterpreting, and I say so with absolute respect to my colleagues, is that we are taking one clause and attempting to have that clause address a number of issues that are captured in subsequent clauses. And I fear that we may be doing a disservice both to our own deliberations as well as to the bill that we have gone through. But anyway, let me hear your point, Madam Minister. Right, so you are the Minister of Constitutional Affairs.
We're all here, Minister, to get some clarity. So, subclause 3 that is highlighted provides that subsection 2 does not apply to record or document which may be by promotion in nature or prohibited from disclosure by virtue of any enactment. So what does 2 say? Subsection 2 says, pursuant to 1C, the minister shall ensure that all records and documents relating to the interaction and communications between the government and the tobacco industry is made available to the public. So when the Ministry of Finance, for example, communicates with the industry about taxes, is that responsibility placed on you to make sure that those informations are made available to the public? I'm just giving you an example. So where your duty, your mandatory duty of ensuring that the records are made available to the public hinges is that the public health policy of the government, which relates to tobacco control, shall for ensuring that there is transparent and documented interaction between government and the tobacco industry. Is that reading correctly from the chapeau? The public health policy of the government, which relates to tobacco control, shall provide for ensuring that there is transparent and documented interaction. Provide for ensuring. It just seemed a little awkward to me, but if it's correct. So it is cast as widely as this, or does this relate to reports that must come to Parliament for the minister? Because if the minister's duty to ensure that all of the communication between the industry and the government is made available to the public, by what means, and how is the minister going to discharge the duty? What comprises all records? I mean, where? Does it come in the form of a report, an annual report to the Parliament when certain things are done? I'm just saying so that the minister doesn't fall into error, or that he does not end up breaching the duty that is placed on him.
Is it on the same? Are you going to comment?
It's the same clause.
Right. I was just wondering if a member, you want to comment on that same point, or it's a separate point? Because as we said, what's coming after?
It is the same point, but and good evening, everyone. Sorry for my tardiness. I was trying to listen in as to the happenings. And sorry to bring it back, but I think that this also relates to Clause 3, where a decision, I think, was made. However, I would like for us to revisit, because I think it actually impacts on Clause 7. So Clause 3, where we relate to, or we're considering inclusion of public and or public body. With the inclusion, I just looked up definition of public body, and the public body defined as a formally established organization that is publicly funded to deliver a public or government service.
A public body defined in our law differently.
Okay, so, well, even then, the point that I'm trying to, and why I had made that suggestion earlier to include public bodies separate from public, is that the industry, the tobacco industry, could make a change to their product and opt to say that they will not inform the public body and will wait until they inform the public before the body that is governing said change is made aware of that change. And so, in effect, the responsibilities that we are considering at 7 would be a bit more obscure. So if we included that they are to inform public bodies as well as separate from public, you are now laying the responsibility on them, not the minister, to see to the enforcement of the information that gets to the public. Because the public body functions in a way that is separate and apart from public.
I made the
And I heard you made it.
I made the very same point.
Yes.
And I was overruled.
I heard you made the point.
Or outvoted.
And I pressed the accelerator a little quicker at that time. Thank you, Chair.
But we kind of going back from whence we came. But I guess it's good exercise. So how, Mr. Edwards, you want to comment? We have to make a decision, folks, and move on. I think. Mr. Edwards, or anybody on this side.
Well, I just want to be clear on, I mean, I appreciate the concern being expressed by Minister.
She's basically saying what I had said, that public bodies require a higher level of awareness and understanding, and may require a kind of customized approach, if you will, which is why the emphasis is worthwhile or important, and then the public where the messaging may be different, that they are more around avoiding as opposed to teaching people to avoid. That kind of awareness may be not similar. And I can relate to it as a communicator. I understand that if you target your audience with a different strategy and approach, but it could still be captured under public because you can adjust the strategy, nevertheless. But for emphasis, it would take.
But Chair, we recall that this was one of the issues that was raised in the earlier deliberations when the matter of having specific communication strategies for different groups was raised. I think the question of inclusiveness and accessibility to different groups in terms of how information is communicated, how awareness is raised, was also brought to the fore by some of the groups. And maybe Senator Longmore's group association may have brought up the whole issue of why not have different types of strategies for communication and awareness raising.
You have to have different types of.
Yes, but we thought that it wouldn't be necessary to specify that in the objects clause.
I understand.
So, Chairman, Member Guy and I just kind of came to a bipartisan suggestion to say relevant public bodies.
No, relevant public bodies and the public.
Yeah, that way it's not. But you're at least making sure the ones relevant are covered.
And you're going to have to define what the relevant public bodies means. Which are relevant public bodies? I'm
very sorry if I'm holding it up. If you want to make the decision and just put on Hansard that I am off this.
There's another level of debate and discussion that will happen, of course, in the Parliament, and I'm sure the Parliament, in its wisdom, will force a decision one way or the other, both chambers, upper and lower house. So maybe we should just agree on the one that we had said we would agree on and just proceed. Can we do that? Yes? All right, just proceed then. So just use public for now, and then I'm sure Senator will have a chance to champion that cause, and so will I, by the way, in the lower house. All right? All right, we really do need to move now. So what is the decision on Clause 6, Education and Information Campaign? Sorry, Clause 7, redrafted. Mr. Edwards, we're going to give you some time to recalibrate that. Is that all right?
Redrafted to what end, though, Chair? We would need to be guided as to what's the mischief.
I think what the minister is to do and that making available to the public needs to be I think more narrowly provided for. So does it come through a statement in the Parliament? Annual report to Parliament? It's very wide, and as wide as it is now may result in unintended consequences.
It's deliberately so, though, Chair, and to you, to Minister, it's deliberately wide because this is, in fact, this is a type of provision.
So give me an example of how he's to ensure that it is. Make sure his ministry has a web page that has it up. Make sure that He goes and talks to the public periodically. He
well,
engages in news discussion.
Minister, through the chair, this is not an obligation on the minister primarily. This is an obligation on the government. In other words, this is a statement. Of course, cabinet is the principal instrument of policy, but it's not the minister who is making government policy. The Minister of Health is implementing. So this provision is primarily obligating the government as a whole, the administration, to ensure that the public health policy covers certain topics. Not that the minister is to make the policy, but that the government policy should cover certain topics.
Thank you. And maybe that's what it needs to say, so the clarity can be achieved. The AG's office, you're okay with it as is? Yes? No?
Chair, can I?
No, let me hear what Ms. Aldred. You have no comment.
You see, Chair,
that's not such a good that's not such a good response.
Chair,
if you want some time to look at it, I'll allow some time, because at this rate we're going to have another session to finalize this. But my thing is, I see the relevance of it, Mr. Edwards,
yes,
and colleagues. I'm just saying, if there is further clarity required, then we can allow some time for it to be redrafted. I mean, is it that the AG's office is saying they understand it and it seems fine, or it's not relevant? I mean, there must be a position.
Mr. Chairman, if I may,
yes,
please.
Yes.
In that very same clause, clause 7, okay, there we go. 7.1c, the public health policy which Minister Malahoo Fort had read. The public health policy of the government relating to tobacco control shall provide for ensuring that there is transparent and documented interactions between government and the tobacco industry, and that such interactions are made available to the public. I'm wondering, why do we need a subclause 2? Why do we need it? Why do we need to say in subclause 2 that the minister shall ensure, if we've already said in 1 that the policy relating to tobacco control shall provide for ensuring this transparency and documentation of interactions? Can't we just include here that such interactions be made available to the public, and take out the responsibility of the minister? Know that it's necessary.
I have to agree, Minister, with Senator Golding, because that's exactly why we were having issue with it. We were not able to determine what exactly it was solving by being this additional clause, because it actually is addressed in 7 subsection 1. So it's almost repetitive and might not be as necessary as we think it is. Maybe in the first instance, it might have seemed more necessary. But as it is now, there is no need, I think, for it, having said clause 1C, 7.1c.
Okay, so tell you what, let me rule on this, if exercise chairman's privilege. I'm going to pause on this clause. I'm going to ask Mr. Edwards to consult, maybe the AG's office and, even the Minister of Constitutional Reform and Legal Matters, or legal matters, that is, and then you come to the next meeting with a clear position. I got the impression from your first statement, Mr. Edwards, that you did not give this particular clause much thought, because you're still seeking advice from us. Is the advice that has been had from the discussion clear enough for your review?
The discussion has been very helpful, Chair. Thank you.
Thank you. So we have achieved something out of this discussion. So let's move on to the clause 8, limited interactions with the tobacco industry by persons who who has responsibility for tobacco control, Clause 8.1.
I'm so sorry, Chair. Just a quick question. Is it that the committee definitely wants Clause 7?
We want whatever makes the bill most effective and efficient. So I'm neither here nor there if the consensus is that it is important and it strengthens the legislation. In other words, I can't give you a yes and
The reason I didn't want to weigh in before is because, from my perspective, this clause is irrelevant, having regard to the mandate in the Constitution that says all policy of the government is determined by the Cabinet. So at the end of the day, no matter what this bill says about what the policy of the government is, it cannot override the mandate given in the Constitution by the Cabinet to determine all government policy.
Okay.
So
that's the kind of contribution that we would have benefited from earlier, but we're happy that
it just seemed as if the committee seemed to have been wedded with this provision, and
no, I think the discussion is what is exactly that. What purpose does it serve, and is it clear enough? So we just need to determine on it. So
Chairman, there is an additional issue. When this bill could only have been tabled in the Parliament after Cabinet has approved the policy behind the bill, the issuance of drafting instruction, and after the report of the Legislation Committee to the Cabinet, and it is now being reviewed. The entire clause, I think, has to be revisited. It is very oddly provided. What is contained in it is odd.
Hence, my ruling that we pause and consult and report back. And Mr. Edwards has full leverage and reach to discuss with your office as well as the AG's office. Okay? So let us agree on that and then move on to the next. Thank you. So Clause 8, limited interactions with the tobacco industry by persons who are responsible for tobacco control. Clause 8.1, an amendment should be made to the provision to make explicit the intent of the interaction of a person who acts for or for the benefit of a public body which has responsibility for tobacco control with a person in the tobacco industry. The technical team is to provide the considered amendment to the provision. And I yield again to the technical team. Did you come up with an amendment appropriate?
We did, Chair. We focused on 9, and I would welcome consideration of what we proposed or what the ministry has proposed in relation to 9 and see how that may play out in relation to 8, because there's the relationship between the two clauses.
So should I read 8 then and then you comment after?
9.
9.
Yes.
So 9, Clause 9, prohibition on partnerships and endorsements of the tobacco industry, acceptance of voluntary contributions, etc. It was recommended that the clause should be clear on any potential conflicts of interest and the avoidance of same, and that penalties be applied to public officials and public officers for any breach based on their role in the public body or in influencing tobacco control policies. Your committee felt that a strong signal should be sent to other public officers regarding their participation in any activity regarding the tobacco industry. The provision should be applicable to elected officials along with the appropriate penalty for any breach of the provision. It was agreed that contributions from the industry should be placed in the Chase Fund to provide sponsorships such as scholarships for students, and this will prevent sponsorship being used as a promotional tool. So that's for 9. So you have now 8 and 9. Mr. Edwards, you can comment.
Thank you, Chair and members. So in relation to 9, the thinking coming out of the ministry, and I say the ministry because the technical team is going to be deliberating fulsomely on this. But the first proposal, if I may refer to the funding issue, is that we would have a provision speaking to obliging every tobacco manufacturer, distributor, importer, or exporter of tobacco products in each financial year making a contribution to the Chase Fund of an amount to be determined, and the basis would have to be determined. I think Ministry of Finance, of course, would have to be involved in this. But it would be an amount to be determined, and the basis could be the value of the products manufactured or imported in that financial year. So that would address the issue of the contribution to the Chase Fund. And of course, the Chase Fund is the Culture, Health, Arts, Sports, and Early Childhood Education Fund that has been established under the Betting, Gaming, and Lotteries Act. So that is a proposal in relation to contribution. Now, in relation to Clause 9, in seeking to address the concern as to potential conflicts of interest and ensuring that penalties be applied to public officials and public officers, what the committee may consider is a proposal to define public official. Now the bill speaks to, in Clause 9, a person employed with a public body. This does not clearly cover the gamut of personnel and officials that we believe the committee wanted the provision to address. So if we speak of public official, where we now have person, and we define public official in a manner that is similar to how public official is defined under the Integrity Commission Act, then we would have a much broader scope to speak of public officials being any person holding an executive or an administrative or judicial office, whether appointed or elected, whether permanent or temporary, or whether paid or unpaid. Any other person who is employed to a public body or performs a public function, and any member of the security forces. So that is broadening the scope of the application of the provision. So if we do that and use the term public official throughout, it would address the matter of the need to apply this both to public officials and public officers. However, we would also propose that in relation to sanctions, there be a differentiation in sanction for persons who are actually involved in the implementation of public health policy for tobacco control, as opposed to persons who are not so engaged. So the proposal would be that in relation to the official who is in an entity or who has responsibility for the actual administration of public health policies for tobacco control, there would be a criminal penalty. In relation to the person who does not have that responsibility but nevertheless is a public officer, then there could be disciplinary or other sanctions. So these are some of the changes that we would invite the committee to consider. The major one being broadening the scope to speak of public official and not just a person employed in a public body.
Chairman.
Okay. I have a question. Okay, you want to go ahead?
Yes.
So but before, where would that go in relation to the two clauses? Are you folding those into one, or?
No, Chair. I just wanted to invite the committee to consider the proposal in relation to 9 before we go to 8.
Fair enough. Let me hear, member guy.
Chairman, I was not at this particular meeting on March the 10th. I'm looking at the minutes, and there's a section of March 10th I recall hearing and seeing in the media where Senator Gale spoke to about some concerns as well as Senator Allen. And I'm looking at the minutes here as it relates to, and I read, Senator Claus said the challenge he had with this clause was that it allowed for criminal liability for anyone who contravened any of the provisions. The chairman stated that the committee should be explicit on conflict of interest with the tobacco industry, and he had an issue with criminal liability being placed on someone who inadvertently invests in a pool of funds. He asked how the issue could be addressed, and I'm specifically referring to 9.3. Mr. Edwards responded that there were different approaches in the Commonwealth to deal with sanctions for public servants on conflict of interest related to personal activity and investment. He explained that criminal sanctions were not always the most appropriate tools, but countries have provisions in a code or regulations for public officers on the issue of investment activities. He noted that these were possibilities that the committee could examine. And further, it went on to say the chairman suggests that there should be a clarity on conflict of interest and avoidance of same, and determination to be made on how the penalties could be weighed to suit the matter. Mr. Edwards said that technical team will need to consider same, and there were other considerations as whether there should be a distinction of the sanction according to the role of the officer. I've not seen or heard any of this being articulated just now in terms of what the concerns of the committee was on March the 10th, and I crave that this be done at this particular point in time, unless, of course, Mr. Edwards is going to come back to us with that.
I would like to endorse that what Member Guy just said, Mr. Chairman, because this was really a point of, I don't want to say contention, but great concern that needed further information. But I'll allow, Minister, if you can allow me to ask a question of Mr. Edwards before you would want him to address that first.
No, go ahead. Is it?
Okay, it's relating to what he had outlined as the proposal.
Yes, that's where we're at.
Okay, so he had proposed that, I'm not going verbatim here, that the tobacco companies make a contribution based on their, I guess, business for the year, the amount of business they do or a percentage thereof. Can Mr. Edwards or anyone from his team indicate how the contribution is currently calculated that goes towards Chase Fund and how it differs based on what is currently proposed?
Chair, I'm not aware of a current obligation to contribute to the Chase Fund. Is that what?
Yes, the taxes that are collected from alcohol and tobacco, my memory serves it correct, there is a percentage that goes to supporting health, whether through the NHF.
Oh, not the Chase Fund. Oh, okay.
No, Chase has a I think 25% of the Chase funds go to health. And therefore ultimately finds its way back into health centers and other health-related activities. So we would need some clarity on that, because what you'll be doing is proposing a parallel scheme that already exists. I also think that maybe in this instance, while you want to avoid the promotions around gifting, you may still want to allow for some determination in terms of the industry as to where they would want to channel this. So if it's a scholarship fund, I don't know if you can dictate to them that they must give 15% or a percentage of their sales. They may have to decide what they want to give, and then it is channeled to the particular, not from them, via a third entity to the particular cause. I think you may, yes.
Chair, I just wanted to intervene. I think, if my memory serves me correct, this particular point came about when we were discussing the voluntary scholarships that the entity would have been dispersing through their CSR departments. So I think that's quite separate from the taxes, which is mandatory. So what we were suggesting now is that instead of saying they should not give scholarships, whatever they deemed necessary to give to their CSR, they would just automatically forward it to Chase.
But what is being proposed is that they commit to a particular percentage, as I understand it, a percentage of their sales, while currently what they do is give what they clearly think they want to give, what they're based on. So you're kind of changing the dynamics of how much is given and who determines how much is given, which is tantamount to another tax.
It's akin to a levy.
Sorry?
It's akin to a levy.
Yeah, exactly. So this is the point I'm making, that you're changing the complexion of the dynamics by now forcing the entity to give while they were voluntarily giving. When the objective, the injury you're trying to address really is that if they decide that they want to give, they should give to a third party who would then administer the gifting. You understand what I'm saying?
Mm-hmm.
So I see a qualitative difference in terms of what you're trying to address there, and I wonder whether or not that is the...
In fact, Chair, where we were looking at what happens in some other jurisdictions, notably Ireland and Kenya, for example, the model, well, can't call it the model, but their experience in relation to the tobacco industry is a prescriptive one, such as this, where you prescribe. In fact, Kenya has a fund, a tobacco control fund, and they just have a specific percentage of profits that the industry contributes towards the fund, which goes to health and
and I'm saying that happens now.
Yes.
It happens now. So.
But is it prescribed in this way? I thought the intention was that we wanted something more definite and prescriptive rather than voluntary. Chair.
Yes, Minister.
Chairman, I think the discussion has gone a little way beyond what I would like to probe. So may I seek your kind indulgence to go back to Clause 8.1 and Clause 8 itself before coming to 9, what you indicated had some reference. So the comments on Clause 8 on the sheet 8.1 is that an amendment should be made to the provision to make explicit the intent of the interaction of a person who acts for or for the benefit of a public body which has responsibility for tobacco control. So it would mean inserting that if you inserting something at 8.1, if this recommendation is to be accepted. Mrs. Seeley Brown wants to weigh in through you, Chair.
My notes, I don't know if anyone else's notes reflect this, but my notes reflected that the words in furtherance of a business activity were too wide, and this activity should be limited to any type of activity that promotes the interest of the tobacco industry. That's what I remembered from the discussions that we had, and I have it here noted in my draft. So that would limit the interaction.
Well, thank you for that clarity, because it's one of the points that I was seeking some explanation on. The other, at subclause 2 says that all interactions referred to in 1 shall be transparent and documented. And then 3 creates the offense in relation to the contravention of 1. So what is the link between the document that is to be made of the interactions and the offense when there is prosecution? And isn't it that it is the documentation is the tool by which you achieve the transparency? Because when the documentation is looked at, you'd be able to see what the interaction was like in terms of what is recorded? And wouldn't it have some relevance for proof in the event that an offense is charged? Yes, evidentiary-wise.
It should. It should.
Right. So what is provided for here needs to be relooked at. And even the use of the term transparent. So you don't, it's not usual for you to say in the law that the documentation must be transparent by mandating that it should be documented in writing. That, so that when you resort to it, you get a good idea of what happened. Does seem that what we are seeking to capture is not clearly provided for.
That is so, Chair and Minister. So that is an outstanding matter for us to resolve in time for the next meeting in relation to Clause 8. In relation to Clause 9, Chair, is in relation to the Chase Fund. We just wish to be clear as to what.
I think you need to check. We need to check to be clear on the Chase Fund issue, because I think we run the risk of duplicating the proposal, and I think it's addressing a different issue.
You can tell me if my understanding is correct. Is because of the prohibition that is placed on interaction with the tobacco industry, and in the light of their sponsorship of events, which would go contrary to the goals of what we're seeking to achieve and the kind of relationship that you would want between or public bodies and this industry, is that in the event that they're making contributions, those contributions are to be channeled in one direction, and that's in the direction of the Chase Fund, which is established for a particular reason. And so you would know, instead of persons individually getting the benefit, that's something that has to be considered for the policy implications of it, and really if that is what you want to do. But separate and apart from that, I have an issue at Clause 9.3 in the Jamaican context. So 9.3 provides that a person employed to a public body shall not, A, provide any incentive, benefit, privilege, or preferential tax exemption in relation to manufacturing or advertising and promotion of tobacco products or relevant products in a person, to a person in the tobacco industry. Now, in Jamaica, under our laws, who it is that provides tax exemptions and by what means? So even though we have central government and local government, local authorities have no remit over tax and the provision of tax exemption. That authority is vested in the Minister of Finance under laws, even where the minister is empowered through order to do certain things, and even where a discretion is given within a particular remit. So I don't know if the provision has been borrowed from another jurisdiction, but it certainly does not take into account how things are done here in Jamaica under Jamaican law.
And that's Clause 9 you're referring to?
9.3 in particular. In other words, I get the impression, reading it, that it's just so cast so widely that we really haven't given sufficient thought and care in whom we're targeting and what it is that we're forbidding. We just cast it so widely. When that is done, you have difficulty in enforcement and the law lacks clarity.
Except that tax is just one of the elements. I mean, we have several activities there. We're talking about provision of incentives, benefits, privileges, or tax exemptions, not all of which activities relate to the minister responsible for finance.
I cited it as an example. So, but all of these refer to some monetary, if it is read and interpreted, ejusdem generis, kind of. Maybe not, maybe not. Maybe not. Let me not get into any technical interpretation of it. Right?
Would the change to public official help, Minister? The fact that public official is a much broader category of persons now.
And Chair, if I could come in at this point with the proposed definition, the proposal to change the definition of public official, I'm querying where we're including judicial offices. I'm not sure it's appropriate for this legislation.
Judicial offices were, through you, Chairman.
It's in the proposed amendment.
It's included because, as I said, we were looking at the Integrity Commission legislation. And when we look at legislation elsewhere, for instance, I looked at the legislation in the Philippines, they relate this type of activity in relation to the control on interaction between industry and the public officials as restrictions akin to anti-corruption measures. In fact, the disciplinary and other sanctions that apply to officials in countries such as the Philippines are very much related to the anti-corruption activities. They see the conflict in such a way that is one akin to the minimizing corrupt practice. So that is why we thought that the public official scope that appears in the Integrity Commission Act would be useful in this context, and that as much as we would not want to think, but I don't know if Madam Solicitor General is proposing that judicial officers may not be open to the challenge that this provision seeks to address.
So if I may, I don't consider this a corruption issue. I can't say how this is a corruption issue, and if it is a corruption...
It's not specifically corruption.
Right, and if it's a corruption issue, it would be adequately addressed under the Integrity Commission Act and fall under the acts of corruption, which are still in Section 14 of the Corruption Prevention Act. However, I'm going to go further. You have said that this is loosely based on the Integrity Commission Act, but there are differences. So the Integrity Commission Act defines a public body in a different manner than it does in this bill. And so when you then refer to a public body in this bill, it has a different context. So for instance, in the Integrity Commission Act, it includes public companies. You don't have that here. It specifically includes municipalities, municipal corporations. You don't have that here. Granted, municipal corporations could perhaps fall under statutory body or authority. I'm just saying, though, that the definition is not on all fours with the Integrity Commission Act. Now, there's a reason the Integrity Commission Act defined public body in the way it did. There's a reason it defined public official in the way it did. And that's because we had international obligations. We had entered into a treaty, and we had international obligations which we had to implement. So this is why I'm asking, why do we need to actually provide for judicial officers in this bill? I'm not sure the relevance of it, of including it here, especially when you're looking at things like you are now saying persons can't invest. You're putting in a whole lot of prohibitive actions in clause 9.3, including investment. And, you know, we have to always be careful because some of us, even public officials, it's not just private sector persons, public officials, persons in government, can actually have stocks and can actually have shares.
You
can have a mix of shares that you are not even aware of, that your investment company can decide to do, and you can run afoul of this.
Madam Solicitor General,
I'm just asking why we're doing that.
I hear you. Can I interrupt you a little bit respectfully? All right, so ladies and gentlemen, Mr. Edwards, just mute your mic for me, please. It's now 4 o'clock, and I am going to terminate or recommend that we terminate the discussions here, given the time. But I want to say a couple of things as a concluding, my concluding remarks. I'm tempted to feel that we're going over the bill and repeating what was said and addressed and discussed the first time around. And at this rate, we're going to be, I think, not be as efficient as we would like to be in bringing some conclusion to advance the process forward. That's one. The issues around investing and so on, as outlined by the SG, is something that we discussed at length and drew some conclusions, and then challenged the technocrats to craft a potential response that we would now consider today. And I think to repeat these things is an indication that either we didn't participate sufficiently the first time around, or we missed it. Either way, it's not efficient. Secondly, I also would want to recommend, Mr. Edwards, that there is a bit more consultation before we get to this phase of the summary and the recommendations. I think we lose valuable time and efficiency by not having a conversation with the critical arms of the different agencies around the proposed changes. So I am going to recommend that some discussion takes place with the AG's office and with the Ministry of Constitutional, Minister Malahoo Fort's office, ministry, and if necessary, the benchmarking against some of the standards that are global standards. And so when the clauses or proposed changes come here, we have a smoother transition if necessary. And the committee is where most of the burden would lie in signing off or asking or probing, but not the agencies that could have addressed and clarified and come to some conclusion before the meeting takes place. I don't get the impression that that consultation took place. And I think for efficiency, it would have been better for it to take place. So I'm going to recommend to the Parliament that we schedule a meeting for 2 weeks' time, or thereabouts, and that when we would have had that meeting, other meetings would have taken place that would involve and include greater technical collaboration to establish greater clarity so that the members who are on the committee would be the ones burdened with trying to determine if this is the acceptable approach. But there is greater agreement at the level of the sub-agencies. Is that okay?
Chairman, just to say, Mrs. Seeley Brown is here from the Ministry of Legal and Constitutional Affairs and can be part of the work with Mr. Edwards, but it will also require someone from your policy side.
Yes, of
course.
The
ministry was dealt with it. Because some of it is not just the drafting, but it's just the clarity around the policy.
Yes, exactly. Yes, yes, but I want to give a little more time. So I want to not have that meeting next week, and maybe go to the end of the month. Actually, I might be traveling, so it may actually be very early July. Huh? It may be early July, yes, like the first week in July. So we give ample time also for that consultation and discussion to take place. Is the 7th of July acceptable to everyone? 7th? That's a Tuesday? Oh, yeah, what's the Tuesday before?
It's a Thursday.
Yeah. And the other Tuesday after that is what date? Again? Oh, Lord. The Tuesdays are not good. What about a Wednesday?
Other committees are actually scheduled for that time. We also work on the 14th.
But the 14th is a Thursday. Member guy has the first and third. So the second is good. So the 14th is good. The 14th? Yeah. Can we go with the 14th then? That's a month or more. Morning will be better, I think. 10? And we go until we finish. So just block the day, please. Huh?
It's an all-day meeting.
If necessary, because we'd have allowed enough time for some clarity to be brought. Is that fine, the 14th?
Chairman, just to say, I already have something scheduled, but if I'm not here, my presence shouldn't impact the meeting. But the work will be done.
Right. And you will provide some guidance, I'm sure, in the meetings leading up to this point. So can we lock in the 14th then of July?
Yes.
At 10 a.m. and we'll try to go on even if we have to break for lunch.
14th of July from 10 to
okay.
10 all day for the next meeting.
Or start 9 and try to see if we can think. But
I'd appreciate 10 minutes though.
Okay, you appreciate that. Because we would like you to be in the chamber.
No, I will be. I promise I will be.
As opposed to being all the way out in the tourism resort.
Chairman, I will need
city.
Chairman, I will need to join virtually that day because I'll be out of the jurisdiction.
Okay, all right, fair enough. All right, so in conclusion then, we will... Yeah, you could. So the 14th, we try to complete, but if not, we go to the following Wednesday, which is what date? The 20th at 2. Yeah. All right. Put those two. Well, we're going to try and do it on the 14th. All right.
Chair?
Any other business? Yes, Mr. Edwards.
Sure. Just seeking some clarification in relation to the report of the committee and the preparation of the report. What's in terms of the next steps?
Well, what I would like in the next meeting is to complete, with the amendments or proposed amendments, the summary sheet. So the consultation that I would like to take place over the next 3 weeks or so would involve the AG's office, your office, policy, and of course the legal and constitutional ministry, relevant individuals. So that
and legal reform department and legal reform.
You don't see, Mr. Nasir around two of them, you know? You're sure, you know?
All right, Madam Member Lee, can you mute your mic, please, Member Lee? All right, so that we can have a smoother flow, because I think some consultation may be needed on some of the issues. And then, importantly, whatever decisions we take, I think we should, as best as possible, benchmark against what the global standards are around some of these clauses and interpretations. And that's not to say we will accept all of them, but at least we would know exactly how we're being guided, right? Yes, and there'll be exactly. All right, and then from there we can move for the appropriate report. All right, so if there is no other business, I am going, and we have the next meeting proposed for the 14th. I'm going to move for an adjournment. So moved by?
So moved.
So moved by Member Mallow Fort, seconded by Member Longmore. Thank you very much. I don't have my, I'll just punch the table. Meeting adjourned.